All right. Welcome back, everybody, for another deep dive.
Yeah.
This time, we're looking at something you might think is a little dry at first.
Okay.
The U.S. Federal Rules of Evidence. But stick with us. I think you'll find it's a lot more interesting than it sounds.
Yeah, definitely.
As you've been reading through articles and legal analyses and even some quizzes,
It's a lot.
you've probably realized that there's a lot to unpack here.
Absolutely. It's a whole system designed to ensure fairness and reliability in legal proceedings.
Yeah, exactly. And it can get pretty complex.
Oh, yeah.
So we're here to kind of help you distill the most important parts.
Right.
And kind of give you a framework for understanding how this all works.
Absolutely.
Plus, we're going to be looking at how a presidential assassination attempt actually changed these very rules.
Yeah.
It's pretty amazing.
That's right. It's fascinating how a single event can kind of ripple through the legal system.
Absolutely.
And change the way we determine truth in court.
Yeah, for sure.
So-
But let's start with something I think you encounter probably more often than you realize.
Okay.
Hearsay.
Right.
You hear it every day, but in a legal setting, it's a whole different ballgame.
Yes, it is.
So can you kind of break it down for us? What is hearsay in the legal world?
So think of it this way. You're in court, and someone tries to testify about something their friend told them, claiming it proves a point about the case.
Right.
That's hearsay.
Okay.
It's an out-of-court statement being used to prove the truth of what it's asserting.
It's like a legal game of telephone.
Right.
And as we all know, things can get pretty distorted
Absolutely.
when you're relying on secondhand information.
That's exactly right. The person who made the original statement,
Yeah.
they aren't there to be cross-examined,
Right.
to swear an oath, or to have their credibility tested.
Right.
So it's inherently unreliable,
Makes it.
and that's why it's generally inadmissible in court.
So it's not about silencing people. It's about making sure that we're using the most reliable information to make decisions, especially when somebody's freedom or well-being is on the line.
Exactly.
Now, you mentioned the case of John Hinckley Jr.,
Right.
the man who attempted to assassinate President Reagan.
Right.
And there was a lot of public concern over the potential use of hearsay in that case.
There was.
Can you kind of tell us a little bit about what those concerns were?
Well, I think a lot of it stemmed from the high-profile nature of the case.
Mm-hmm.
You know, this was a presidential assassination attempt.
Yeah.
People were very worried that unreliable statements could sway the outcome of such a significant trial.
Yeah, you wouldn't want a jury basing their decision on just rumors or gossip.
Right, exactly.
But of course, there are exceptions to every rule.
Right.
And hearsay is no exception.
Of course, there are times when a hearsay statement might be considered reliable enough to be admissible in court.
Okay.
For example, imagine someone confesses to a crime. That's pretty powerful evidence,
Right.
even if it wasn't said directly to the court.
Yeah, that's a pretty clear-cut example.
Yeah.
What about statements made by someone who works for a person involved in the case, like an employee or an agent?
Right. So those can also be admissible under certain conditions.
Okay.
The idea is that if someone is acting on behalf of another person, their statements might be considered more reliable than just random hearsay.
Right. So there's like a connection there.
Right. Exactly.
But it's not just a free pass.
No, absolutely not.
There are still very specific requirements that need to be met for these exceptions to apply.
Absolutely. And that's where things can get tricky.
Right.
Take the co-conspirator exception, for instance.
Okay.
To use statements made by one conspirator against another, you'd have to prove that the conspiracy actually existed.
Right.
And that the statement was made in furtherance of it.
Right. So you can't just say, oh, they were friends, so they must have been in cahoots.
Right, exactly. It has to be much more concrete than that.
Okay, now while we're on the topic of exceptions,
Yeah.
let's clear up a common misconception about hearsay.
Okay.
The classic fire in a crowded theater example.
Yes.
So the scenario is someone yells fire in a packed theater,
Right,
causing panic and a stampede.
right.
Is that hearsay?
It's a tricky one, but it's actually not hearsay.
Okay.
The statement isn't being used to prove that there was actually a fire.
Okay.
It's being used to demonstrate the impact of the statement itself.
Got it.
Why people panicked and ran.
So it's not about the truth of the statement,
Right.
but rather its effect on those who heard it.
Exactly.
It's about the consequences,
Yeah.
not the literal content.
Yes, and that distinction is crucial
Right.
in understanding when a statement might be considered hearsay
Gotcha.
and when it falls outside of those boundaries.
Makes sense now. Moving from panicked moviegoers to another key player in the legal world.
Okay.
let's talk about expert witnesses.
All right.
Because these are the folks that lend their specialized knowledge to help the court understand complex issues.
Right.
These aren't just random people with opinions.
No, not at all.
They need real expertise, proven qualifications, and a commitment to remaining neutral.
Right.
Their job is to illuminate, not advocate.
Exactly.
But what's really interesting is the distinction between court-appointed experts
Okay.
and those hired by one of the parties involved in the case.
Right.
So what's the difference?
Well, a court-appointed expert is chosen by the judge.
Okay.
Usually when a neutral, unbiased perspective is especially important.
Okay.
It's like the court saying, we need someone who can provide an objective opinion free from any influence.
So who pays for that court-appointed expertise?
It depends.
Okay.
Sometimes it comes from a designated legal fund, especially in criminal cases.
Okay.
But sometimes the involved parties share the cost as determined by the court.
Okay, so that's interesting.
Yeah.
Now, what about the experts hired by the parties themselves?
Okay.
Wouldn't there be a temptation for them to favor the side that's paying their fees?
There's always that possibility.
Right.
That's why the rules surrounding expert testimony are so important. Opposing counsel has the right to rigorously cross-examine any expert,
Okay.
regardless of who hired them.
Right.
This is to test their credibility and expose any potential biases.
So it's not just a free pass to spout whatever your side wants you to hear.
Exactly.
You are accountable under oath, and your opinions can be challenged.
Right.
It's a system of checks and balances to make sure things stay fair.
Exactly. And the court can even exclude an expert's testimony
Oh, wow.
if it's deemed unreliable or biased.
Interesting.
So this system really helps protect the integrity of the process.
Okay.
Now, remember that Hinckley case we talked about earlier?
Yeah.
Well, it actually led to some important changes in how expert testimony is handled,
So
especially regarding mental state.
I think so. Didn't it have something to do with like a specific rule about insanity or something?
It did. Rule 704B was added to the federal rules of evidence after the Hinckley case, and it prohibits experts in criminal cases from giving their opinions on whether a defendant meets the legal definition of insanity.
So an expert can't just say, this person was insane at the time of the crime and have that be the end of it.
Right. The reasoning behind this rule is that deciding guilt or innocence is the jury's job.
Got it.
Not the experts.
Okay.
The jury needs to consider all of the evidence.
Right.
Not just an expert's opinion on the defendant's mental state.
It makes sense. You wouldn't want a situation where an expert's opinion essentially overrides the jury's role
Exactly.
in determining the facts of the case.
Exactly. And this rule helps maintain a clear separation between a medical or psychological diagnosis and a legal conclusion.
So, for example, an expert could testify about a defendant's diagnosed mental illness.
Right.
But they couldn't directly say, therefore, they were legally insane at the time of the crime.
Exactly.
So they can present the medical information. But the jury ultimately decides what that means in a legal context.
Right.
It keeps those roles distinct.
Precisely. The Hinckley case, though controversial, really highlighted the importance of this distinction.
Yeah.
And led to a significant change in how expert testimony is handled.
Interesting.
Especially in cases involving mental health.
Yeah. It's fascinating how one case can have such a lasting impact.
It really is.
On the way we approach evidence in legal proceedings.
Yeah.
Now, speaking of experts and how they present their findings.
Okay.
There's another rule that really streamlines things.
Okay.
Rule 705.
All right.
So tell me a little bit about that one.
So this rule is all about making expert testimony more efficient.
Okay.
Instead of needing to explain all their reasoning up front, experts can now simply state their opinions first.
Oh, so they can jump right to the conclusion?
That's right.
Doesn't that seem a little out of order?
It might seem that way, but it actually makes things move faster.
Okay.
During cross-examination, the opposing counsel gets to dig into the reasoning and the basis for the expert's opinion.
So it's about getting to the heart of the matter quickly.
Right.
And then letting the cross-examination kind of unpack the details
Exactly.
and test the expert's conclusions.
Right. It allows the expert to present their key findings up front. And then the cross-examination explores the why behind those findings.
Okay, and I bet that cross-examination is where things can get really intense.
Oh, absolutely.
It sounds like a verbal chess match.
You could say that.
With the jury watching every move.
Yeah.
But before we delve into the drama of cross-examination, there's another aspect of evidence we need to explore.
Right.
Prior statements.
Okay.
So we've talked about hearsay.
Right.
We've talked about expert witnesses.
Right.
What are prior statements,
Correct.
and why are they important in the grand scheme of evidence?
So prior statements can be a bit confusing because at first glance, they seem like they should just be considered hearsay.
Right. They're not being said under oath in the courtroom.
Right. Exactly.
So how can they be admissible?
The key is that certain types of prior statements are considered reliable enough to be admissible, even though they weren't made during the actual trial.
Okay, so it's not a blanket ban on any statement made outside the courtroom.
Right.
It's more nuanced than that.
Exactly.
So let's focus on maybe like the three main types of prior statements that are generally admissible.
All right.
Prior inconsistent statements.
Okay.
Prior consistent statements. And prior identification statements.
Got it.
Okay, so let's break those down.
Right, yeah.
What is a prior inconsistent statement, and why would it be allowed in court?
Okay, so imagine a witness testifies in court and says, I saw the defendant running from the scene.
Okay.
But then records from a police interview surface. And in that interview, the witness said, I didn't see anyone running away.
Okay.
That earlier statement directly contradicts their current testimony.
So it raises serious doubts about their credibility.
Right, exactly.
They've changed their story, which makes you wonder what else they might be misrepresenting.
Exactly, and that's why that prior inconsistent statement can be used to impeach the witness's testimony.
Okay.
Even though it wasn't said in court.
It's like saying, hold on, you said something different before, so how can we be sure you're telling the truth now?
Right, exactly.
But there must be some rules around this.
Yes.
They can't just be any casual conversation from the past.
Right. For a prior inconsistent statement to be admissible, it typically needs to have been made under oath.
Okay.
Like during a deposition or a grand jury hearing.
Okay.
This lends more weight and seriousness to the statement.
So it's not just hearsay, it's potentially perjury?
Right.
If they're contradicting a statement they made under oath.
Right.
Okay, now what about prior consistent statements?
Okay.
Those seem a little bit trickier.
Yeah.
Why would you need to bring up something someone said before if it's the same as what they're saying now?
It's all about context.
Okay.
Prior consistent statements are primarily used to rebut accusations that a witness fabricated their story or was pressured to change their testimony.
Okay.
Let's say the opposing counsel suggests the witness was coerced into saying something.
Right.
Or that they recently made up their story.
Okay.
A prior consistent statement made before the alleged fabrication or coercion helps bolster the witness's credibility.
It's like saying, no, they've been saying this all along.
Exactly.
It's not some new story they concoct.
Yeah, it establishes a pattern of consistency.
Got it.
And refutes the claims that the witness's story is a recent invention.
Okay, I'm starting to see how these seemingly minor details can actually make a big difference in building a case.
Absolutely.
Now, what about those prior identification statements you mentioned?
Okay.
Those sound pretty straightforward.
They are. In a way, these statements are all about identifying a person.
Okay.
Let's say you witness a robbery, and right after you tell the police, that man right there is the one who did it.
Right.
That statement, even though made outside the courtroom, can be admissible as a prior identification.
Now, what about the reliability of memory?
Right.
People can be mistaken.
Yeah.
Memories fade over time.
Absolutely. But the thinking is that identifications made close to the time of the event are generally considered more reliable than those made much later.
Okay.
The memory is fresh, and there's less opportunity for outside influences to taint the recollection.
So it's like capturing that initial raw memory before it gets distorted or influenced by other information.
Exactly.
But the witness who made that prior identification would still need to testify in court, right?
Absolutely. They would still need to take the stand and be subject to cross-examination about that prior statement.
Got it.
It's not a free pass.
Right.
Just because the statement was made soon after the event.
So there's still that opportunity to test their memory.
Yes.
And challenge their identification.
Exactly.
Which helps ensure things remain fair and balanced.
Exactly. The rules are designed to strike a balance between the need for reliable evidence and the right to a fair trial.
Yeah.
It's a delicate balance, but it's a crucial one.
Absolutely.
Yeah.
I'm noticing something in our notes here about a mysterious Rule 803.
Yes.
Is that related to these prior statements?
It is. This is where things get really interesting.
Okay.
Rule 803 is like a Pandora's box of exceptions to the hearsay rule.
Oh, boy.
It lists 23
Only 3
specific situations where hearsay statements are deemed admissible.
So even if someone isn't physically present to testify?
Right.
their statement could still be allowed in court.
That's right.
If it fits one of these exceptions.
Exactly.
It's like a legal escape hatch for hearsay.
Yeah, you could say that.
But each exception must have its own specific conditions and limitations, right?
Yeah, absolutely. It's not just a free-for-all.
Yeah, okay.
For example, one exception is for what are called present sense impressions. These are statements made while or immediately after someone perceives an event or condition.
Right.
Like, a witness describing a car accident as it happens.
Oh.
So it's like a real-time account of what they're seeing or experiencing.
The idea is that because the statement is made so close to the event,
right,
there's less chance for memory to fade or for fabrication to occur.
Exactly. It's like a snapshot of their immediate perception.
Got it.
Another interesting exception is for excited utterances.
Ooh, those sound a little more dramatic.
Yeah.
What are those all about?
An excited utterance is a statement relating to a startling event.
Okay.
Made while the person is still under the stress of that event.
Okay.
Like someone yelling, "He has a gun!" during a robbery.
So it's like a spontaneous reaction.
Yes.
In the heat of the moment.
Exactly.
The logic is that the intensity of the situation makes it less likely that the person is thinking about lying or making things up.
Exactly. Their adrenaline is pumping.
Yeah.
And their statement is a visceral response to what's happening.
Yeah, we could spend hours going through all 23 exceptions. But let's not get too bogged down in the details.
Yes, yeah.
What's like the main takeaway for a listener when it comes to this Rule 803?
Okay, the key is that even though hearsay is generally inadmissible, there are many exceptions that allow certain types of out-of-court statements to be used as evidence.
Okay.
And these exceptions exist because the courts have recognized that there are situations where hearsay statements can be reliable and trustworthy.
So it's a lot to keep in mind.
It is.
It seems like you really have to look at each situation carefully.
You do.
And consider all the factors before deciding whether a statement fits one of these exceptions.
Exactly. And that's what makes understanding the federal rules of evidence so important.
Yeah.
Whether you're a lawyer, a witness, or just someone who wants to be a more informed citizen.
Right.
But there's one more fascinating category of statements under Rule 804 that we need to touch on. Dying declarations.
Dying declarations.
Yes.
Ooh, those sound pretty intense.
Yeah.
What makes those admissible?
Okay, so Rule 804 deals with situations where the person who made the statement, known as the declarant, is unavailable. And as you might guess, unavailable in this context can mean deceased.
So we're talking about those final words whispered on a deathbed.
Right.
Those can actually hold legal weight.
They can. Dying declarations are statements made by someone who believed their death was imminent.
Wow.
And those statements concern the cause or circumstances of what they believe to be their impending death.
So the reasoning is that someone facing death has little incentive to lie.
Exactly.
There's a certain weight and solemnity given to those final pronouncements.
There is.
It's a chilling thought.
Yeah.
But it makes sense. From a legal perspective, you're trying to extract truth from a situation where the usual rules of testimony don't apply.
Precisely. But of course, like all hearsay exceptions, there are conditions that must be met.
Yeah.
The person must have genuinely believed death was imminent.
Okay.
And the statement must directly relate to the cause or circumstances of their believed impending death.
So it's not just any random deathbed confession like, I stole that cookie from the jar back in 1987.
Right, exactly.
It has to be relevant to the circumstances of their death.
Exactly. There's still a lot of scrutiny involved.
Right.
Even when dealing with someone's final words.
Wow.
But these dying declarations can provide crucial insights.
Yeah.
Especially in cases where there are no other witnesses.
Right.
Or when the circumstances surrounding a death are unclear.
Okay.
Yeah.
So we've covered so much ground today.
We have.
From hearsay and its many exceptions.
Yes.
To the complexities of expert testimony and even the weight of dying declarations.
That's a lot.
It's clear that the rules of evidence are designed to navigate a very intricate landscape. And we've seen how a single case, like the Hinckley assassination attempt, can send ripples through the legal system and change how we approach evidence and testimony.
And the federal rules of evidence continue to evolve as we encounter new challenges and technologies.
They do.
Absolutely. It's a constantly evolving area of law.
It is.
But the core principles remain the same, ensuring fairness, reliability, and the pursuit of justice.
Exactly.
All right, well, stay tuned, folks. Our deep dive continues after a quick break.
Absolutely.
Welcome back. We've been exploring the world of evidence.
Yeah.
And how it's used in legal proceedings.
Right.
And now we're about to enter a part of the process that can be incredibly dramatic.
Yes.
Cross-examination.
It's definitely where things can heat up.
Yeah.
Cross-examination is a cornerstone of our legal system.
Mm-hmm.
It gives each side the chance to challenge the other side's witnesses.
Right.
And really test the strength of their evidence. We've all seen those courtroom dramas where a skilled attorney dismantles a witness's testimony with a few pointed questions.
Right.
It's like a verbal duel and the stakes are high.
Oh, yeah.
But is it always about making the witness look bad?
Well, while it might feel that way sometimes, the main purpose of cross-examination is to test the credibility of a witness and the reliability of their testimony.
All right.
It's about exposing inconsistencies, challenging assumptions, and helping the jury decide how much weight to give to the witness's statements.
So it's about getting to the truth.
Exactly.
Not just scoring points.
Right.
And this applies to both expert witnesses and regular everyday witnesses.
Absolutely.
Okay. So whether it's a neighbor testifying about what they saw or a world-renowned scientist explaining complex data.
Right.
They're both subject to cross-examination.
They are.
So what makes a cross-examination effective?
Okay.
What are some of the